delegates. I'm very pleased to be here with you. I know we don't have a lot of time, so I'm just going to present my opening remarks so that we can get to the questions right away. The Quebec government focuses on dialogue and cooperation with the federal government. Usually, it appears only very rarely before committees, federal government committees, whether they be House committees or Senate committees. Under Quebec's statement that affirms Canadian relations unveiled on June 1st, Quebec indicated its intention to seize all opportunities to have its voice heard across Canada, and that includes federal parliamentary committees where necessary. The Federal Minister of Justice has sought to create a national regime of cannabis legalization. And we believe that this is beyond the scope of the legislative jurisdiction of a federal parliament acting on its own. She also seeks to support people who would like to contest the constitutional validity of certain provisions of the Quebec law further to the adoption of Bill 157. In this context, I felt it necessary to accept your invitation to present the viewpoint of the Quebec government. So first I will talk about the production of cannabis, that is in homes, and then the reliability of the producers of cannabis. The federal government decided to withdraw from the criminal code some elements concerning cannabis, not all of them, but some. Decriminalization of cannabis, the growing of cannabis at home when the number of plants is equal to or lower than 4 is a consequence of the federal parliament's exercising of its legislative jurisdiction in terms of criminal law. This means that the production of 5 plants or more in people's homes is a crime. This new legal space for cannabis leaves some questions up in the air for example, production and marketing, and those questions are under provincial jurisdiction. And it is not because both Ottawa and Quebec are legislating on the same topic that there is automatically a conflict between the two pieces of legislation. Under the application of the doctrine of federal paramountcy, a provincial law is constitutionally inoperable when it comes into conflict with the federal law. There is the conflict of objectives and the conflict of application. So let's talk about the objectives. There is a conflict where the provincial law is incompatible with the objectives sought by the federal law. Therefore, we must ask whether the provincial law hampers the carrying out of the objectives set out in the federal law. The federal government says that it acts to protect public health and safety. The purpose of this federal law is not to authorize the possession or the growth of cannabis for personal purposes, but rather to protect young people and public health and safety. In fact, in the summary of the federal law, it is written that this bill seeks to prevent young persons from accessing cannabis, to protect public health and safety by establishing strict product safety and quality requirements. In addition, in an article published in a Canadian document, it says that the provincial governments and territorial governments will deliver permits and oversee the distribution and sale of cannabis subject to the respective minimal federal conditions. It could adapt certain rules applicable in their own province and territories or municipalities, and these rules could include the establishment of additional regulatory requirements to solve questions of local interest. For example, the provinces and territories could raise the minimum age or restrict the possession or growth of cannabis in people's residence by reducing the number of plants or limiting the places where cannabis can be cultivated.
Soutenir que l'interdiction de cultiver plus de 4 plants.
Saying that the banning of cultivating more than 4 plants of cannabis at home is an authorization of growing cannabis flies in the face of the decision of the Supreme Court of Canada in Rothman, Bences and Hedges against Saskatchewan, which said that the federal power to legislate in terms of criminal law can be exercised and interpreted only to ban these acts and not to authorize acts. On its face, the federal bill calls on federal legislative jurisdiction with regard to criminal code and seeks to amend a number of sections of the criminal code. Paragraph 8(1)(e) of the federal bill must be interpreted as a ban on growing more than 4 plants, not as an authorization, an unachievable authorization of cultivating or growing between 1 and 4. In the case Western Canadian Bank against Alberta, Justices Binney and LaBelle said that courts must be careful when they analyze a potential federal-provincial conflict of interest. They said that the fact that the federal legislator has legislated on something does not mean that we must presume that it excludes the possibility of provincial intervention. It appears clearly that the Canadian government does not seem to intend to occupy all of the leeway with regard to the possession and culture of cannabis for personal purposes. It leaves the scope to the provinces to restrict that even more based on their own priorities and circumstances. Therefore, Quebec, taking into account the amendments brought to the criminal code and the decriminalized aspects of cannabis, is creating its own authorization system based on its legislative jurisdiction, which are based on its own jurisdiction with regard to ownership and private law. Therefore, Quebec also intends to legislate to protect the health and the safety of its residents, especially those of young people. It is because of this important protection of public health and safety that we want to authorize the production of cannabis by authorized producers elsewhere than in people's homes. Therefore, to limit the accessibility and to avoid normalizing cannabis for minors and young people, accessibility is the greatest determinant of cannabis use. And we also want to do this to offer relevant information in the sales outlets. At this time, we will be able to determine whether some people need to be referred to social service that are adapted to their state. Growth in the home prevents us from providing relevant information and from observing whether certain people have particularly specific needs stemming from the consumption of cannabis. And finally, we are doing so to limit the illegal market for cannabis and to ensure that a supply chain of personal producers is not created. Both of our governments have the same intent. There is no conflict of intention. We are exercising our respective jurisdiction to protect public health and safety. Neither is there a conflict of application between our laws, or in the bills for the moment. A conflict of application is a situation where a citizen violates a law by seeking to obey another law. Here, the federal government has only chosen to ease the application of the criminal code, but it continues to prohibit a certain number of things in this area. For example, it is prohibited to produce cannabis without having obtained a permit from Health Canada. Producing without a permit is criminal. There cannot 5 plants or more and being grown in the home is banned. That is in the order of criminal law, and it's the same thing for minors or adults possessing cannabis. Therefore, the federal government has established a new framework for cannabis in the criminal code by requiring that producers have permits to ensure the quality of the facilities, the product, its traceability, its processing and its sale, and also for research with regard to these products. The provincial rules will be complementary to the federal rules, so it is not about excluding our rules because we have the power to authorize and to choose the criteria of the authorization. Therefore, Quebec has provided for rules that will ensure the quality of the products, the vetting of the producers, the education of the public, all measures that are seeking to avoid normalization of cannabis. Ottawa's actions have freed up the space necessary for Quebec to exercise its jurisdiction in terms of private law, and it is doing so by authorizing the production of cannabis in certain areas, but not in people's homes. Can a citizen obey both laws at the same time? Well, the answer is yes. Quebecers who do not grow any plants will be obeying both Quebec and federal legislation. In fact, Quebecers who obey the Quebec law will obviously and clearly be obeying the federal law as well. Therefore, there is no conflict of application here. The federal government has not drafted and cannot draft in legislation that it is authorizing 1 or 2 or 3 or 4 plants being grown at home, because that's provincial jurisdiction. All it is doing is prohibiting 5 plants or more being grown in the home. Because criminal is prohibitive, the federal jurisdiction cannot be exercised, it can only be exercised to ban actions and not to authorize actions. The federal justice minister came before this committee, I believe, to tell you that her bill is one that seeks to create a national system for legalizing cannabis. But that expression does not seem accurate to me. The minister can decide to review the provisions of the criminal code concerning cannabis. She can decide to review the rules of prohibition concerning cannabis. But as far as managing the effects of decriminalizing and legalizing cannabis, our 2 levels of government are both concerned and must work together. One of them must set the level of prohibition, and the other one must put in place authorizations. Once again, this complies with what the Supreme Court ruled in the case of Rothmans, which I mentioned earlier, which said that through criminal jurisdiction, the federal level prohibits and provinces authorize under their legislative jurisdiction. Therefore, there's no conflict of intention or a conflict of application, and therefore, no legislative amendment is required to achieve the purposes that we in Quebec are seeking with our bill. However, and this is why I'm here in part, what the federal minister said about possible people challenging the law is problematic. Because the government is saying to the citizens, we are with you in challenging provincial law. And in our opinion, this statement is unfortunate and in addition has no legal grounds. It encourages challenges, and that flies in the face of what we could call cooperative federalism. I have come before you today to say that in our opinion, we have the constitutional jurisdiction that allows us in our authorization regime to decide where we will authorize the production of cannabis. We have decided that these places would not include people's homes and would be limited to production by authorized producers. In fact, since the Minister of Justice came to claim that the federal government could create a national legalization regime, we believe that is wrong and that she was encouraging people to challenge our law. Therefore, we feel it is timely, in order to avoid needless legal recourse, that the bill should be more specific. You could make an amendment to avoid court challenges, prevent court challenges, and to show that we agree to have federal and provincial parliaments who work together instead of one against the other. I have talked to you about this from a legal aspect, but now I'm going to talk to you about the political aspect from the angle of cooperation. It is the federal government who chose to amend the criminal code. It obtained a mandate to proceed to decriminalizing and legalizing cannabis, and that is not something that we are challenging. We are dealing with this decision. Is it easy? No. Have we had to do a great deal of work to adjust to the new context? Of course. But we are doing it because we are part of a federal system where we are called upon to cooperate, each according to our own jurisdictions, for the sake of cooperative federalism. I would like to ask the federal government to also act to respect cooperative federalism. And that means respecting the provinces and the choices that they have made in all legally and legitimately. The federal government is confusing, in my opinion, the federal regime and a unitarian regime when it is seeking to create a national regime to legalize cannabis all on its own. In a federal system, the different levels of government are equal and must be respected and must respect each other. We must respect the legality and legitimacy of each other's actions. Quebec is doing everything in its power to accompany the federal choice, and it is respecting Ottawa's legality. And Quebec expects respect in return when exercising its jurisdiction, when it decides on an authorization regime that allows for production outside of people's homes. Now, with regard to the financial aspects, The government of Quebec is concerned by the financial interests linked to the production and marketing of cannabis. Therefore, we added to our bill information that will create a framework and vet the interests that are linked to cannabis. Until such time as the Public Market Authority is operational in a few months, the AMF will manage a accreditation regime using police powers and the Revenue Quebec, which has links with Revenue Canada. We will verify the producers and the directors thereof, and whether they are private companies or listed on the stock exchange. We will also be vetting all shareholders with 10% or more of a share. We will also vet the shareholders of the producing companies, and in that case, all shareholders with 20% or more of the shares will be vetted. In comparison, the vetting that Ottawa is intending to do to provide permits are the same that is being done for medical cannabis. Ottawa is not vetting the shareholders, the shareholding companies that are listed on the stock exchange. It is only vetting those who have 25% more of shares. So we can see that Quebec is vetting, the Quebec vetting exercise is much more stringent, and therefore we think that Quebec is the only province to have such a regime, with the other provinces going with the medical cannabis regime. Secondly, we have included the investigative and seizure powers so that we can use a proof that is stemming from these investigations to impose criminal offense, to punish criminal offenses. So we have taken very stringent measures in terms of integrity, because so that we don't do through the back door what we can't do by the front. So we wish that the federal law would be just as would have as much integrity. Thank you.